Welcome to part 5 of our redundancy focused mini-series. I'm Charlotte Geeson, and during this video I will be talking to you about collective redundancy consultation. The obligation to collectively consult presents itself when an employer proposes to dismiss as redundant 20 or more employees within a 90-day period. Employers who are required to collectively consult must consult on the redundancy proposal with representatives of the affected employees and notify BEIS. The relevant legislation concerning collective consultation is Section 1888 of the Trade Union and Labour Relations Consolidation Act, or TULCRA for short, which implements the European Collective Redundancies Directive. The collective redundancy consultation provisions of TULCRA are complex, but they can have really important commercial consequences. So it's important that regard is had to them and that they are followed. Perhaps the two most notable consequences are that the obligation to consult operates in effect as a moratorium on the proposed dismissals. What that means is dismissals in a collective consultation process can't take effect for a minimum period of time once consultation has started. And secondly, that there is a sanction for breaching the collective consultation obligations. That sanction is presented as a protective award, which can be up to 90 days pay for each affected employee. Given that the collective consultation obligations don't kick in until you're talking about 20 employees or more, that protective award can add up to a very substantial amount very quickly. When it comes to the question of when the duty to collectively consult arises, as aforementioned, this will primarily happen when an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. It is, however, really important to note that dismissals are classed as a termination of employment contract, and by reason of redundancy means that the reason for the dismissal did not relate to the individual concerned. The definition then of a redundancy dismissal for the purposes of collective consultation is far wider than when we're looking at what I suppose is the normal working definition of redundancy, and can actually include terminations for other things, including unsuccessful variation to contract processes. When the obligation to collectively consult does arise, there are strict guidelines to follow in respect of who an employer must inform and consult with. Under the legislation, the duty to inform and consult is with appropriate representatives of the affected employees, and where the duty arises, the employer, like I say, must also notify BEIS of the proposal, with the failure to do so being a criminal offence. So, breaking that down then, an affected employee is an employee who is affected by the proposed dismissals or by the measures proposed to be taken in connection with the dismissals. The reference then to an affected employee is quite wide, and obviously far wider than perhaps the sort of normal working definition of redundancy that we're all used to provides. The reference to appropriate representatives has a specific meaning, and it means either a trade union, where the employees fall into a category which recognises a union, and in other cases, employee representatives who are directly elected for the purposes of consultation by the affected employees. Where there is no trade union, an employer will actually have a choice as to whom to consult with, and it may choose to consult either with representatives directly elected for the purpose by the affected employees, as I say, or with employee representatives who have been appointed for purposes other than for discussing the redundancy proposals. So that includes things like a pre-elected works council. The employees themselves will have no right to insist on a particular course of action when it comes to consultation in this respect, and the decision is with the employer. In practice, most employers choose to consult with reps directly elected rather than with a standing body, because overall, practically and sometimes legally, it can be far simpler to do so. When it comes to the election process, there are rules relating to situations where employee representatives are to be specifically elected for the purposes of collective consultation. And by way of summary, I would say the following. The employer is under a primary obligation to make sure the election arrangements are fair and reasonable. The number of representatives to be elected is ultimately up for grabs and a decision to be made by the employer, but that employer should ensure that there are sufficient representatives to represent the interests of all of the affected parties. The employer should determine before the election process the term of office of the employee representatives so that it is of sufficient length to enable information to be given and also for consultation to be completed. So the moratorium periods, which we'll come on to, will either be 30 or 45 days in length, depending on the number of employees who are affected. But what you may want to do is appoint your representatives for a slightly longer period. So there's a bit of overhang, perhaps at the start and the end of that moratorium period, to allow for the consultation process to be properly concluded, and also to allow you to have the ability to successfully adapt to any changes which may be necessary to the consultation process as a result of the discussions that you have with the representatives as you work through the consultation process itself. All candidates for election of the employee representatives must be affected employees on the date of the election. Now, I get asked quite often whether or not it's possible to have individuals from other departments who aren't at risk of redundancy being employee representatives or standing for election, and the answer to that is no. Similarly, it's not possible to have a manager of a department who perhaps themselves aren't at risk of redundancy stand for election as a representative. Representatives have to be affected by the proposals themselves in order to be able to stand. No affected employee should be unreasonably prevented from standing for election, and all affected employees on the date of the election are entitled to vote for the employee representative they want. Employees are entitled to vote for as many candidates as there are representatives, and the election should be conducted overall so that as far as is possible, the ballot is in secret. If you are looking to embark upon an election process in this respect, I would suggest that you take advice to ensure that the process is adequately formulated and followed to meet with your requirements. And one of the reasons that I say this is because a breach of the election rules in particular can carry the same protective award as for other breaches of the collective consultation process, i.e. that 90-day protective award. And because it is for the employer to show that the election was carried out in line with the legislative requirements as opposed to the burden being on the employee, the stakes can be quite high. Just as a final point on elections, when it comes to the timing of elections, there's no specific time frame set out in any of the legislation, but the elections do need to have been completed before the actual consultation and moratorium period can start. Just taking a step back to a reference that I made earlier about the requirement to notify BEIS. As I say, this is a really important part of the process, and employers must do this by using a HR1 form. The HR1 form can be downloaded from the internet, and it's not a particularly complicated form, and it's not a long form either. It is a criminal offence not to notify BEIS of any intentions with regards to collective consultation, and the offence is one which can attract a level 5 fine, which is basically an unlimited fine. Previous companies who faced proceedings in this respect include CityLink and Sports Direct. The latter quite famous for being in the news with regards to employment law issues. The CityLink directors, I have to say, were acquitted, but nevertheless it made for some interesting headlines at the time. The HR1 form itself should include the identity of those appropriate representatives and also the date on which the consultation is due to start. The HR1 form must be copied to all representatives who are to be consulted with, and it must be submitted at least 30 days before the first dismissal takes effect in cases involving 20 to 99 redundancies and 45 days in cases involving 100 or more redundancies. In terms of the process of consultation then, the legislation requires the consultation to begin in good time. And obviously there are certain minimum time periods which do apply in a collective consultation case. Where 100 or more redundancies are proposed, like I say, the consultation must begin at least 45 days in advance of the first dismissal taking effect. For fewer than 100 redundancies, the minimum period is 30 days. It is really important to remember as you work through a collective consultation exercise that because a voluntary redundancy is also classed as a dismissal in law, no voluntary redundancies can actually take effect either until that minimum consultation period is passed. The process of consultation will start upon the provision of information of the proposals to the representatives. This information needs to be provided in a specific written format to comply with the legislation and must include the following as a minimum. The reasons for the proposed dismissals, the numbers and descriptions of employees to be made redundant, the total number of employees and any such description employed by the employer at the establishment in question. It must include the proposed method of selection for dismissal, so selection criteria, the proposed method of carrying out the dismissals, including any procedures and relevant periods of time over which the dismissals will take place, the proposed method for calculation of any redundancy payments to be made, and also suitable information about the use of agency workers. If you are an employer looking to embark upon a collective consultation process and you have agency workers in the mix, then I would advise you to take some advice in terms of what that reference to suitable information about the use of agency workers will mean for you. Much like with individual consultation, so maybe the normal sort of redundancy consultation that we're all used to, collective consultation must be undertaken with a view to reaching agreement on ways and means of avoiding the dismissals. This may involve reaching agreement on ways to reduce the number of dismissals or mitigating against their consequences, for example. But either way, it is not sufficient for an employer to simply explain its proposals and listen to any counter proposals without actually taking any kind of affirmative or practical proactive steps to actually implement or at least consider any such proposals. It is possible, as parties work through consultation, that there will be changes to the proposals. I mean, ultimately, this is one of the whole reasons for the process. And in this situation, the employer's obligation isn't just to provide the appropriate representatives with relevant information at the start of the process. It will be under an obligation, a continuing obligation, to provide updated information about any developments that present themselves during the consultation process. There's a really fine line in practice between a proposal being kind of adjusted in such a way so that actually the consultation is a furtherance of the initial proposal, and the proposals being shaped and developed in such a way that they become something entirely different. In that latter situation, you need to be mindful, because it may be that a tribunal would find that where proposals had been significantly and sufficiently changed during consultation, the employer would no longer be continuing with its original proposals and therefore would be under an obligation to start a brand new collective consultation process. When it comes to the moratorium question, it's a really common misconception that the act of collective consultation must last for the full duration of that period, i.e. 30 or 45 days. In fact, the legislation clearly states that this time period is only relevant to the period which must pass before a dismissal can be effectuated. In practice, many employers will consult for the full moratorium period, and certainly as far as we're concerned, this is a very prudent approach to take, because the danger in issuing notice of termination during the moratorium period is that the employer won't have been or can be argued as having not allowed its consultation process to have run its course. Once notice of dismissal is issued, this is effectively the employer saying consultation is over, at least in respect of those dismissed employees. Since the obligation under TOLCRA is to consult with a view to reach an agreement, the process of consultation should continue for as long as appropriate in order for parties to reach an agreement, or alternatively exhaust the possibility of reaching an agreement. That said, a collective consultation process is not, however, open-ended, and ultimately, whatever the response is from the employee representatives, it is clear that at some point, an employer will need to cease consultation in order to commence redundancy proceedings and give effect to its commercial proposals. Some of you watching may recall the affectionately named Woolworths case, and I miss Woolworths, I have to say. This case rumbled on for a few years, but it concerned collective consultation, specifically the reference to the definition of establishment for the purposes of the obligation to collectively consult. Now, Section 188 of TOLCRA states that the duty to consult applies only where 20 or more dismissals are proposed at one establishment. The European directive definition doesn't really help to explain what this actually means, but in the Woolworths case, the European Court of Justice, the ECJ, confirmed that it was actually permissible for employers to treat workforces at different sites as singular establishments for the purposes of collective consultation. The primary effect of this was that it was not necessary for employers to aggregate proposed dismissals across various sites for the purposes of collective consultation, which is helpful. In addition to providing this clarification, the ECJ also offered some guidance in a different judgment in terms of what actually constituted an establishment for the purposes of the legislation. The guidance that the ECJ came up with is complicated in parts, but in essence and very generally, the ECJ said that an establishment should be loosely defined, and it may, therefore, consist of anything which is capable of being stated as a distinct entity with a certain degree of permanence and stability, which is assigned to perform one or more tasks, and which has a workforce and technical means and a certain organisational structure to allow it to do so. When it comes then to the question of whether a site is capable of being classed as an establishment, there can be some questions as to whether that is the case or not, and it might be one of those scenarios where you want to seek independent advice. Additionally, when it comes to the question of whether an employee is specifically assigned to a particular establishment or not, the situation can get tricky, particularly with mobile workers. And again, advice on that point is also something that we would probably advise that you take. If you are embarking upon a collective consultation exercise in the near future, there are a few practical tips that I can give you for effective consultation. But the sort of overriding, I think, comment would be to make sure that you are clear on what your obligations are from the outset, so that you don't fall foul of any of the provisions and you don't open yourselves up to exposure for the protective award, but also any other claims for unfair dismissal, breach of contract, etc. In terms of some practical tips then, I would say that ultimately planning preparation is key. If you can get your details, your consultation process, your prep right from the outset, then you're halfway there. In addition to sort of prepping those key details, establish your business case for redundancies, because that is what the whole process ultimately needs to tie back to. In order to make any sort of changes, dismissals, you need to have an objective business rationale ultimately that underpins that need for change. And just like in a sort of ordinary, normal redundancy situation involving fewer than 20 employees, everything has to tie back to that. So make sure that you establish your business case for redundancies, and make sure you communicate that across the whole team, all the personnel who are going to be involved in the collective consultation process, so that you can have a very joined up approach, consistent approach in terms of the message that you're delivering to the affected staff. When you are carrying out that planning, have a very clear aware of your proposed numbers of redundancies and also your timescales. Get a draft timeline built up. You can deviate from it if necessary, but if you have something to work with from the outset, it will certainly be of use. Make sure you properly clarify your selection pools and have regard to the selection criteria that you're implementing. It doesn't need to be the case that you apply the same basic generic selection criteria to every single pool that you're working with in a collective consultation exercise. In fact, that's potentially not the right approach to take, because you may not be comparing like for like across your organisation, and you may need to implement different tailored selection criteria to different pools in order for the consultation process to be fair. Either way, if you can bottom out your selection criteria at the preliminary stages, that's only going to be to your benefit in the long run. And I suppose finally, if you can approach the exercise with an open mind, then that again will be to your benefit. As I've said, the whole point of collective consultation, one of the requirements of the legislation, is that employers have a meaningful discussion with their employees, and they actively, proactively, pragmatically seek to look at and consider any proposals for an alternative course of action which may be presented. It's far easier for those conversations to flow naturally, far easier then for you to stay on the right side of the law if you don't sort of go into this process knowing very definitely that there's going to be absolutely no deviation at all. Right, well, hopefully you found this video to be useful. If you do have any questions about collective consultation, the process, your obligations, or anything like that at all, then please do not hesitate to contact us. And hopefully you will join me for part 6 of this mini-series, the final part, where I will be going through some redundancy FAQs and giving you some hints and tips in terms of how to address redundancy situations generally. Thank you for watching.